Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Hey guys, today we're going to talk about if you want to fire your attorney and proceed pro se. I have a friend in Pennsylvania, and Pennsylvania is the state that I fought my own foreclosure in. And as always, I tell you guys, I'm not an attorney. I can't give legal advice. Okay, but if somebody has a question, I can try to answer them based on what I've learned, but it's not legal advice. Anyway, I am helping a friend that lives in Pennsylvania, and we're going to talk about his case today because it's very interesting. Okay, so he is in Pennsylvania, and let's talk about his attorney had filed an answer to the foreclosure complaint because he's in a judicial state. So let's take a look at that real quick. Okay, so this is what the cover page looks like for the attorney that was working on this. Answer, new matter, and counterclaims. And basically the answers that he provided were very minimal. And also the caption isn't right. You would think that the lawyer would get the caption right. It says, Douche Bank National Trust Company as trustee for Sandview Home Loan Trust 2005 OPT1 Asset-Backed Certificate Series 2006 OPT1. That's way wrong, guys. Not even close. So there's a big red flag there. If the attorney can't get the caption right, then there's going to be a problem with his answer. So just to let you know, this guy is not the best attorney for helping fight foreclosure. His name is P. William Bursick, Esquire, and he's out of PA. So heads up, guys, you don't want to get this guy. He's not going to help you very well. Anyway, he answered the complaint pretty much. We won't go over each question to answer because you guys know that these answers are very minimal. Now, his new matter is also very minimal. He doesn't really say much in his new matter. And counterclaims, well, let's see. What his counterclaims are, two things. Where he says, I'm like, wait a minute. That's all he has for counterclaims is plaintiff incorporates the complaint filed in Court of Common Pleas as it pertains to Douche Bank. So, that's just not good enough. If you want to get anything done with your foreclosure, especially if you're a defendant in a judicial foreclosure state, then you need to file an aggressive complaint. And counterclaims that actually are meaningful. So let's take a look at what he's going to do to fix this. Okay, so the first thing he's going to do is send his attorney a letter firing him. So here's what his letter says. I am terminating your representation in my foreclosure case. Douche Bank as trustee for the Soundview Home Loan 2006 OPT1 Asset-Backed Certificates Trust versus Christian Kirsch. Case 20251144. Effective immediately. Please cease all legal activity in this matter and send me a full copy of my case file and all documents you have submitted or received. Sincerely. Okay, so first thing he's doing is firing his attorney by sending him this letter, and the next thing he's got to do is notify the court that he's done this. So let's see what an entry of appearance looks like. This is the proper court heading. The plaintiff is Douche Bank National Trust Company as trustee for Soundview Home Loan Trust 2006 OPT1 Asset-Backed Certificate Series Trust in care of PHH Mortgage Corporation. Now that's how it should have read. Okay, and basically this is telling the prothonotary, please enter my appearance pro se in the above captioned matter, and his address and email is right there. So the court will basically, what they'll do with that is they will file it in the court that he's going to proceed as pro se. So let's take a look at what he's going to file next, how to get rid of that nasty answer and correct it with a good one. Okay, so he's going to file wait a minute here. Okay, so he's going to file first a motion to amend answer and new matter. Comes now, defendant Christian Kirsch, pro se, respectfully moves this honorable court for leave to amend his answer and new matter pursuant to PA Rule of Civil Procedure 1033 and in support thereof veers as follows. Plaintiff filed a complaint in mortgage foreclosure on or about April 21st, 2025. Defendant previously filed an answer new matter and counterclaims through counsel P. William Bursick. Defendant has now entered his appearance pro se and terminated the services of prior counsel. The prior answer contains material errors including an incorrect caption naming the wrong parties, the omission of key defenses including lack of standing and failure to attach or produce the original promissory note, counterclaims which require clarification or revision. The defendant seeks to amend his answer and new matter to correct these deficiencies and asserts all available legal defenses and facts necessary for a just adjudication. Pennsylvania Rule of Civil Procedure 1033 allows amendment of pleadings at any time by leave of court, and such leave should be freely granted. No party will be prejudiced by allowing this amendment, and it will promote the interests of justice. Wherefore, Defendant Christian Kirsch respectfully requests that this honorable court grant leave to file an amended answer, new matter, and counterclaims, and that the attached proposed amended pleading be accepted and filed upon entry of an appropriate order. Okay, and then there's a proposed order that the judge can just sign. It's always good to have one of these in there, make it easy for them to grant that. Now let's look at his amended answer. The first page of his amendment has a notice to plead, which in Pennsylvania has to be on every single filing that you file and have to send to the other side. And that's what this is. And then the next page says answer with new matter and counterclaims. Answer to complaint. And basically these are answers to the complaint. Denied, denied, denied. Look at all that. Denied, denied. Denied, denied. Admitted. That's the only question they ask where he admits that he is the real owner of the property. And then you have all these other denials. New matter. Okay, this is where it gets interesting, guys. And number 10 says paragraphs 1 through 9 of the preceding answer are incorporated herein by reference as if fully set forth. Plaintiff has failed to attach a copy of the promissory note as required under Pennsylvania Rule of Civil Procedure 1147A, which mandates that a complaint in mortgage foreclosure must contain a copy of the note and mortgage. Accordingly, plaintiff has not pled a prima facie case for foreclosure. Defendant avers that plaintiff is not in possession of the original promissory note and is not the lawful holder or assignee thereof. Plaintiff has not established that it has standing to enforce the alleged mortgage loan. The mortgage was allegedly assigned to Douche Bank National Trust Company as trustee for the Soundview Home Loan Trust 2006 OPT 1 on or about October 11, 2011. That's when that assignment was filed. However, public SEC records show that the trust filed a Form 15D with the U.S. Securities and Exchange Commission on January 17, 2007, effectively ceasing its operations and suspending its reporting obligations under the Securities Exchange Act of 1934. A copy of this is attached hereto as Exhibit A1. Defendant avers that Soundview Home Loan Trust 2006 OPT1 was no longer an active operating entity in 2011 and was therefore not legally authorized to accept or acquire new mortgage assets. Any purported assignment made in 2011 is void or invalid, and plaintiff lacks standing to enforce the mortgage or note. Defendant denies that the assignment recorded as instrument number blah 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 in Mercer County establishes a valid or enforceable interest in the mortgage, and strict proof thereof is demanded. Plaintiff alleges that Douche Bank National Trust Company as trustee for this trust is the proper party in interest. However, the caption also identifies PHH Mortgage Corporation care of plaintiff, which indicates PHH Mortgage is acting as servicer only. Defendant avers that PHH Mortgage Corporation is not the holder of the promissory note nor an assignee authorized to enforce the mortgage loan. Under Pennsylvania law and the Uniform Commercial Code, a loan servicer without possession of the original note or explicit authority from the note holder lacks standing to foreclose. Therefore, plaintiff has failed to properly establish standing in pursuit of this foreclosure action. Defendant avers that the entity named as a signer in the October 11, 2011 mortgage assignment, Sand Canyon Corporation, formerly known as Option 1 Corporation, was no longer a functional legal entity at the time of the purported transfer. Publicly available bankruptcy filings and sworn declaration by Dale Sugimoto, president of Sand Canyon Corporation, attached here to as Exhibit B1, confirmed that Sand Canyon had ceased originating or holding mortgage loans by 2008 and had sold or otherwise disposed of such assets. As such, Sand Canyon held no legal interest in the mortgage on the date of the purported assignment, and the assignment is therefore void and has no legal effect. Defendant reserves the right to assert additional defenses and claims as discovery proceeds and further evidence is obtained. Counterclaims. Defendant Christian Kirsch incorporates by reference all prior paragraphs of this answer, new matter, and any attached exhibits as fully set forth herein. Count 1, wrongful foreclosure, lack of standing. Plaintiff has initiated this mortgage foreclosure without legal standing to do so. The mortgage was allegedly assigned by plaintiff by Sand Canyon Corporation on or about October 11, 2011. Public records including a sworn declaration by Sand Canyon's president Dale Sugimoto confirmed that Sand Canyon ceased all mortgage-related operations and no longer held mortgage assets as of 2008. Further, the named plaintiff, Deutsche Bank National Trust Company, as trustee for Soundview Home Loan Trust 2006 OPT1, is not a proper party in interest, as the trust filed a Form 15 with the Securities Exchange Commission on or about January 17, 2007, terminating its reporting obligations, effectively ceasing to operate. As a result, the alleged assignment to plaintiff is void, and plaintiff has no lawful interest in the mortgage or note, and they didn't attach a note. Plaintiff's foreclosure complaint constitutes wrongful attempt to enforce a mortgage without authority, lawful authority, causing defendant emotional distress, reputational harm, and the risk of wrongful loss of property. Wherefore, defendant requests this court dismiss this foreclosure action and award such other relief that may be just and proper, including costs and attorney's fees. Count 2 is violation of the Pennsylvania FCEUA. And basically it says it's the Pennsylvania Fair Credit Extension Uniformity Act. Prohibits false, misleading, or deceptive acts in connection with collection of debts. It's like the state version of the FDCPA, guys. Plaintiff and or its agents, including PHH Mortgage, falsely represented themselves as lawful creditor and holder of the mortgage when they were not. Plaintiff's filing of this foreclosure action based on a void assignment without proof of standing constitutes a deceptive act and practices under the FCEUA. Defendant has suffered actual damages, including emotional distress, legal expenses, and reputational harm. Okay, so that's like count 2. Count 3 is, guess what? Violation of the FDCPA. And as you all know, we like to use this in federal court, not so much in state, but state will look at it, but it's really a federal thing, just so you know. But we're putting it in anyways. Anyway, so basically PHH Mortgage Corporation and other agents are acting as debt collectors under the meaning of the FDCPA, and again, false and misleading representations, so we're going after them for that. And then the quiet title and declaratory judgment is count 4. So he's asking for a declaratory judgment that the assignment is void and quiet the title to the property. And that's pretty much how that works. And then he signs a verification form and certificate of service to the other side's attorneys, and then the exhibits that go with this. Here's the Form 15 that was filed with the SEC, and as you can see, it is signed on January 16th of 2007. That's when the trust ceased operations. And then Sand Canyon Declaration by President Dale Sugimoto. That shows when they ceased to exist. And as you can see here, this is something you can, if you have these parties in your case and you want to use this in your case, it's certainly out there. I can put it on my Facebook page if you need to get a hold of this declaration by the president of Sand Canyon, when he says that is, as of April 30th of 2008, the mortgage loan servicing was sold to American Home Mortgage Servicing, AHMS. So that's basically, they're saying that as of May 1st, this company is basically no longer existing. And it's all here. Yada yada, guys. That's the end of it. So, I mean, in 2011, they didn't exist to transfer anything, is the bottom line. So, guys, I know this was kind of a long video, but it's kind of important because this guy, you know, he needs to argue this kind of stuff if he's going to win his case. And his attorney just wasn't doing it for him. And sometimes you got to fire your attorney and proceed as pro se. And that's what he's doing. Everybody, give him a hand for doing that. It takes a lot of guts to do that. So we help each other. If you have any questions, you can email me at foreclosurehelp777@gmail.com. And thank you for subscribing, and I hope everyone has a blessed day. We are done. Okay, let's see.